Good afternoon, everybody. Thank you for joining us for this month's Embassy Insider. As you recall, last month we were joined by the chief of the non-immigrant visa unit, Martin, to answer your questions on non-immigrant visas. This month we're not joined by one, but two officers who are specialists in immigrant visas. We are thrilled to have you here with us today. My name is Molly Koshina. I am the press attaché here at the embassy, and today I'm joined by Monique and Nathan. Monique, Nathan, thank you for joining us today.
Thank you, Molly. It's a special treat to be here today.
Thanks for the invitation, Molly. We're looking forward to this.
Excellent. Well, our Facebook followers have been submitting questions to us for 2 weeks now, and there are a lot of questions to cover today. Followers, we are not going to be able to get all of your questions answered. So what we've done, we've taken the most commonly asked and the most relevant, and we're going to cover those questions. But we won't be able to get to everyone's because time is short and interest was unbelievably high. So I know that there are questions to get to. First, I wanted to say, is there anything you want to start off just to give everyone an overview with? Immigrant visas,
absolutely,
maybe?
Molly. Yeah, I just wanted to say the immigrant visa process, it is quite challenging. It's quite rigorous. You know, I think of it like a marathon. It's a long race, not a sprint. And Monique and I understand that the process is challenging, but the ultimate benefit, you know, the prize at the end of that race is something really precious. It's the opportunity to become a long-term permanent resident in the United States. And really, it puts you on a path to full citizenship. So we hope that all the effort that the applicants go through is worth it. And Monique and I and all our colleagues, are here to just help people through that process.
Oh, thanks for that overview. Okay, we'll get straight to the questions. So our first question is really about the overall process. Rolando Diaz and Manny Tucson ask, how can they apply for a visa, an immigrant visa, and what are the requirements?
Okay, so Rolando and Manny, I'm not really sure about your particular situation, but I'll try to give you an overview so that you can consider whether you're eligible and want to apply. So in general, the first thing you should consider is whether you have a relationship with an American citizen or a legal permanent resident, also known as green card holder, or an employer that would like to petition you, and they have to be in the United States. So not all relationships are qualified. So let's say that you have a U.S. citizen relative and you happen to be their spouse, their parent, their child, or their sibling, you might be eligible. Additionally, if you have a relative who's a legal permanent resident in the United States and you're their spouse or their child, you might also be eligible for this. So Manny and Rolando, if you've found that you might actually qualify for this, I urge you to take the next step, which is to contact USCIS, also known as the U.S. Citizenship and Immigration Services. Please remember that acronym because I have a hard time repeating it many times. So it's USCIS, and you can find all of their information below. So that's the first step.
Can I ask, would it be the person in the Philippines or the person in the United States who reaches out to USCIS?
Oh, that's a great question. It has to be the person or the petitioner who's in the United States. Yeah.
Okay. Excellent. So Sybil Salazar asks, can you tell us exactly what an NVC is?
Okay.
I don't know what it is either.
Yeah, okay. Well, yeah, that's a good question, and that's a little bit advanced immigrant visa, I would say. So basically, there's a 3-stage process when you apply for an immigrant visa. We already touched on number 1, which is filing your petition with USCIS. Once USCIS approves that, the second stage is that they send your paperwork, your petition over to the National Visa Center, or NVC.
Got it.
And so the NVC takes care of your petition while there are certain petitions that have a wait period, and they might wait until they become current. So a little teaser. Nathan will probably talk about wait times a little bit later on. So it will wait there until it's ready, or NVC might require some documentation, and there might be a back and forth. And so when you've satisfied all of NVC's requirements, the next step, in my opinion, is the best. you get to come to the embassy for an interview with one of us
With
or
one
one
of
of our
you.
colleagues. So that's the third stage in the process.
Wonderful. It does sound complicated. I understand why there are so many questions.
Mhm.
So this is a question that we get a lot, not only online, but just in conversations with Filipino contacts. How early does one need to arrive at the embassy for an immigrant visa interview appointment?
Okay, well, that is a favorite question of mine. So you should arrive no sooner than 15 minutes before your appointment.
Only 15 minutes.
Only 15 minutes. There's no benefit to arriving earlier than that. In fact, you'll just wait. We've really tried to revamp our processing so it goes really quickly. And so if you come earlier, you'll just have to wait. Maybe you'll be in the sun, hopefully not in the rain. So we encourage you to really, please, everybody, come only 15 minutes before and you'll be fine.
I will say it's hard with the Manila traffic
It is.
to time things right.
Yes.
But that's good to know.
Yeah.
It's not much time in advance actually at all. Okay, the next question comes from Hanley Bernardo. And this is kind of a complicated situation, right? So Hanley inquires, my sister and her daughter were interviewed in March for migration to the United States. Their papers were submitted and received. However, my sister's passport was handed back with a request that she get a Japanese police clearance. The problem is, her daughter is turning 21 this April, and she has to enter the U.S. prior to her 21st birthday. With the entire medical and interviews done, can she enter the U.S. after her 21st birthday while waiting for the Japanese police clearance, which will take 2 to 3 months? I understand she can't travel to the U.S. without her mother as the principal immigrant.
Why don't I give that one a shot? That is a long question. I think the essence of that question, though, the concern that Hunley has is concern about her daughter reaching the age of 21 and not being eligible for a visa.
Well, she's still waiting on paperwork.
Exactly. So that is something that all applicants need to be aware of. And there have, mainly it was a bigger problem in the past, actually, where due to our own processing delays on the government side, applications and children would sometimes reach the maximum age and families would get split up. And to avoid that, there was a special law passed called the Child Status Protection Act. And what that tried to do, and it's been pretty successful, is subtract all that processing time in which we are holding the application, where we're holding up the application, from the child's age so that they're not penalized for that. And that has done a lot to reduce unnecessary family separation and that sort of thing. It does apply for many of the visa classes. Still, there are visa classes where the applicant does need to pay special attention to that age out date of 21, and K visas are one. I don't know in Hunley's case what the situation is, but if someone does reach the maximum age, there's always another option too. So a parent could reach the United States and file a new petition for that child in that case. So all hope isn't always lost. There could be another way to file that petition.
But 21 is the magic number.
That's right.
Okay.
For most applications.
For most applications. Okay. The next question comes from Annabelle Tigas Corpus. My daughter was born in the U.S. and she has a U.S. passport. She's now 21 years old, again a 21-year-old question, and graduating in August of this year. We came back to the Philippines and stayed here since she was 1 year old. Now she wants to petition me. Can she do it while we are both here? How long will this petition be processed? Ryan Cruz also asks what his options are if an affidavit of support is required, but he does not have U.S. income tax returns.
Okay, so I think I can take that question. So for Annabelle, it sounds like, as I was talking about earlier in terms of relationships, it sounds like you have an eligible relationship. Your daughter has reached the age of 21, and there is that relationship that's eligible for her to file a petition for you. The question I have in your situation is domicile. You mentioned that your daughter has been in the United States, in the Philippines for quite some time. And by U.S. law, in order to petition for an immigrant, the petitioner has to be domiciled, which also means residing in the United States. So this could be a problem in your situation. What does that mean? We'd look at evidence of whether you're working, living, maybe studying in the United States.
Yeah.
So if that's not the case, all hope is not lost as well. There is a possibility that you could establish domicile. And again, it would be looking at some of your situation. Are you establishing a residence in the United States? Are you working, studying, filing taxes? A lot of different things. But these are really complicated cases, and we look at them on a case-by-case basis. So I would urge you to consider this when you for Annabelle when she moves forward with this. And then in terms of Ryan's question, it also seems as though domicile is an issue in his case. But additionally, I wanted to mention his question about the affidavit of support. So for most visa classes, petitioners would file an affidavit of support, which is a contract or an agreement of financial support for that immigrant. Again, by law, in order to do this, in order to provide that financial support, you have to be domiciled in the United States. So that's something that Ryan would also need to consider as he looks at his situation.
So an affidavit of support couldn't come from the Philippines or, say, England. It must be from somebody who is physically residing in the United States.
That's the case, exactly.
Okay, thank you.
You're welcome.
The next question is from Muj Isacio. Is there discrimination against anyone with physical impediments for applying for immigrant visas? If so, what impediment faces restrictions?
Yeah, I'll jump in there. So Muj should know that there are absolutely there's no discrimination against anyone with a disability. We would welcome the disabled just as much as we would welcome any other immigrant who's applying. And I would even go so far to say that the U.S. is really progressive when it comes to disability rights. We have the Americans with Disabilities Act, which does a lot to accommodate those with disabilities. It tries to stamp out discrimination against the disabled. So nothing to worry about there. There is a medical exam. So maybe Muj is thinking, or other people are thinking about a medical screening. There is a medical screening. And the primary reason for having the medical screening is to pick up detect any infectious diseases, communicable diseases, to protect, the general public health of the population in the U.S. And I know it can seem burdensome for some of our applicants to go through that sometimes long process. And I don't know, I put myself in their shoes, and I would actually feel reassured that the country I was immigrating to did such a good job of screening for communicable diseases and protecting the public health. So. Yeah, I think that's the Muj should have no worries about applying.
Excellent, thank you. The next question comes from Paps Ram. I'm a green card holder, but due to some unavoidable circumstances, I was not able to go back to the United States. I've been in the Philippines for more than 3 years now. My green card is expiring in a few months' time. Can I still go back to the U.S., or should I return my green card or wait for it to expire? What do I do?
Okay, so I'll answer that question, but for PAPS, but for all green card holders, we see these cases all the time, and they can be quite challenging. So my message would be to encourage any green card holder to not stay outside of the United States beyond 12 months, because it becomes more challenging after that to re-enter the United States. One thing that green card holders can do if they anticipate that they might be staying out longer than 12 months is to apply in advance for a re-entry permit with USCIS. I mentioned USCIS earlier. You can find their contacts at the bottom of the screen, but that is sort of a clear path for them. In the case of a green card holder that stayed beyond a year, which sounds like it's PAP's case, there is an opportunity to apply for what's called a returning resident application, and that is an application that you can find information about again at the bottom of the screen. So when you apply for that, we consider each case individually. It's a very complex situation. And I have to say that we cannot guarantee that they'll be approved. In some cases, applicants may actually have to go through the whole process of refiling a new visa. So again, my message, don't stay out of the United States for more than a year. And also, if you anticipate that, contact USCIS in advance because it's a complex process. So I hope it works out for PAPS.
Yeah. Can I ask a follow-on question?
Sure.
The returning resident application.
Yeah.
Would that only be for someone who is intending to return, as opposed to perhaps PAPS, having been here for over 3 years, perhaps wants to stay in the Philippines but wants to maintain that green card? What's the...
Yes, it would.
Okay.
But if in the case of someone like PAPS, we would talk to PAPS and try to really understand his situation. So
Individual.
yeah.
Okay, great. Thank you so much. Now, let's talk about waiting times and priority dates, right? We talked a little bit about this earlier, and this is where we can kind of get a little deeper into the weeds. We've received a number of questions on this. One came from Juliet Dumoal, and then another from Marcos del Castillo, and another from Kim Karingal. How does it work for immigrant visas with regards to waiting times and priority dates? Everyone wants to know.
Right, it kind of seemed like a big puzzle or mystery, right? So the first thing I'm gonna say is what people should remember if they forget everything else that I've said, because
Okay, the one thing to remember,
right.
everybody.
So it's called the Visa Bulletin. Okay, it's a wonderful chart. It's a graph. It resides at the travel.state.gov website. We'll put that link down in the top comments so people can access it. And it's a chart that people can look for their visa class in one of the columns. They can look for the country, Philippines, and they can find out, and they can see what the visa cutoff dates are. So they can see who are interviewing now for the visa class that they hold. So they can then make some educated guesses about when their visa might become current.
What does that mean, become current?
Yeah, that's a good question. I shouldn't have used that phrase, but become current means that they're eligible to be interviewed here at the embassy.
So before they're current, is the case still with the National Visa Center?
Yes, it is.
Exactly.
Okay,
yeah.
so when it becomes current, it comes to us here at the
Yes.
embassy.
Yeah.
Okay.
And the question was about wait times. So the wait times can really vary depending on what sort of visa you're classified as. So immediate relatives, spouses and children and parents, those petitions are pretty much processed as they come in. So there isn't really that long of a wait time. But as you get into these other family preference categories, brother and sister of a U.S. citizen, unmarried son or daughter of a green card holder, wait times start to get longer and longer. And for the Philippines, for instance, the F4, the brother or sister, that person is waiting sometimes 20 years for their interview. And so whenever someone like that comes to my window, I'm always careful to just acknowledge how long they've waited and to say, we appreciate it, it's good to see you. But the reason for those long wait times is that there's a limited number of visas worldwide. So the Philippines is really competing with all the other countries in the world. And the demand here is just really, really great, which means, well, it's really a reflection of the relationship between the two countries. There are many, many Filipinos who have brothers and sisters who are U.S. citizens. So it's just a reflection of the deep ties between our two countries.
And what is the chart called again? Was the
Yes, it's called
Bulletin?
the Visa Bulletin.
Visa Bulletin?
And that link will be down below.
Okay, awesome. Thank you. Next question. Ronit Bana Watson asks, my grandfather is a U.S. Army veteran in the Philippines. My father is his only son. Can I become a U.S. immigrant?
Okay, wow. So it sounds as though your grandfather is a veteran and may be eligible for this a new program that started about a year ago called the Filipino Veterans World War II parole program. And so to be eligible for that program, you have to be a U.S. veteran. And this is in part to recognize that many Filipinos served alongside Americans in World War II. So we want to recognize that. We want to reunite families of veterans who are in the United States and their families here in the Philippines. So it's a great opportunity. We've already actually had 50 applicants who've gone through it, so we're really proud of that. And in order to benefit from this, you, one, have to be a veteran who's in the United States. And secondly, it's a little complicated, but it's for, as Nathan talked about, there are some visas that have a really long wait time. So if you have a petition that is currently you're waiting for your availability, you can apply for this, and if you have a certain relationship with the veteran. And in this case, grandchildren can be eligible. So I would urge her to look at there's a specific website for this program to read about that, and there's actually a very specific email for this program. So they can contact that email and give the particulars on their situation and see if they're eligible.
Can I ask a clarifying question?
Sure.
Does the grandfather need to be resident in the United States?
That's a great question, and I think that does come up a lot. Yes,
Okay.
the grandfather does need to be resident in the United States because the purpose behind this is to reunite families.
Okay,
So,
that is really nice. I think it must be wonderful to issue those visas and see the families get back together. The next question is from Apple Clemente. A green card holder filed an immigrant visa petition on behalf of her daughter who is living in the Philippines, single and without children. Boy, they're complicated cases, aren't they? Okay, so we've got a daughter who's in the Philippines, single, no children. After 10 years, the green card holder became a U.S. citizen while her daughter became a single mother. Since she's already a U.S. citizen, should her daughter choose to be transferred to an F1 visa, or is it better to stay in F2B? How will this affect the daughter's priority date?
Okay, should I take that, Monique? All right. So the salient point here, I think, there's a lot going on there, but the salient point is that I think Apple, was it? She's asking if her petitioner in the United States changes their status. So they've gone from a green card holder to a citizen.
Yep.
What happens to her petition? So technically...
Excellent question, isn't it? Right?
It comes up a lot. So, because a lot of time can go by, and that person in the U.S., their life has changed. Right. They've decided to take the oath, and they've become a citizen. And so the applicant becomes, in her case, an F2B, which would be a son or daughter of a green card holder, now becomes an F1.
Automatically?
Essentially, yes. I mean, because the person has naturalized, so their petitioner has a new status. So they are an F1. Okay. And why this matters, I think why the question is because there can be different wait times for those two visa classes, right? And so what would work best for that applicant? And in this case, the applicant has a lot of flexibility, and they're actually able to sort of decide which situation is most advantageous to them. So if their visa is current, which we know means they're able to interview now as an F1, then they can interview as an F1. If the F1 is not current, there's a process where they can go to USCIS and request an opt-out letter to retain their F2B status. And then we can interview them if the F2B is current, and they can interview for that. So this is a case where what's most advantageous for them is what they should do.
Goes back to getting families together, right?
Mm-hmm.
Interesting. The next question is from David Estrella, and it looks like Crisel Morales asked a very similar question. Is there a possibility that a petition can be reinstated if the petitioner dies?
So I'll take that question. So the answer is yes. Once a petitioner dies, unfortunately that petition becomes revoked at that point. But there's an opportunity for the potential immigrant to appeal to USCIS on humanitarian grounds and request what's called a humanitarian reinstatement. And so if that's approved, the immigrant has to find someone who's either a green card holder or a U.S. citizen who will help carry the process forward. They're called a substitute sponsor. And fortunately, Nathan mentioned the wait times. They will retain their original date, and just continue the processing. So there is that not all is not lost. There is that opportunity.
And does the substitute sponsor need to be a resident in the United States?
Oh, okay. Yeah, that's another good
I keep
question.
wondering.
Yes, the
'Cause
sponsor.
It seems that that's a theme, right?
Yes, the sponsor should be in the United States. Mm-hmm.
But it's nice to know that it can continue,
Mm-hmm.
Yeah.
Yeah.
especially if someone gone on 20 years.
Yeah.
Life happens, right?
Exactly.
And we do see those all the time, so it is possible.
Interesting. Super. Okay, the next question comes from Douglas Sires. What is the process for bringing a Philippine domestic adoption child to the United States? The adopting mother is a Filipino national and a dual citizen living and raising the child in the Philippines. The adopting father is a U.S. citizen living and working in the United States. Are both parents required to live in the Philippines before filing an immigrant petition?
So we're getting close to a case-specific situation here, but I will give some information about adoptions generally that I think will apply to this case. So Douglas asked about adoptions, and I will say adoptions are some of the most complex cases we work on. And there are two types of adoptions. It's not really important, but just so people know that there's something called a Hague adoption and a non-Hague adoption. And because of the phrasing of the question, I think Douglas is talking about a non-Hague adoption. Okay, so in those cases, the requirements for the adoptive parent is that the adoptive parent must have 2 years of legal custody over that adopted child before that child reaches the age of 16. Okay, those adoptive parents also must have resided, basically lived in the same residence with that adopted child for 2 years. And then lastly, the adoptive parents, while they were residing with that child, they must have been the ones who were exercising full parental control over the children, meaning that those adoptive parents were making all, the most significant life decisions for that child. Things, choosing their medical care, picking out schools for them, that sort of thing. Sometimes that's one of the elements that's hard to demonstrate and what can make these cases complex. But if anyone has any questions, if Douglas has questions, once again, we actually have a really excellent adoption site at the State Department website. It goes into this in some depth. So I would recommend that Douglas take a look at that. We'll put that link also down below in the top comment.
Super, super, thank you. Well, unfortunately, that's all the time we have today. Thank you so much for joining us today. I hope that the questions that you asked were answered to you, to your liking. Please let us know what you think about today's Embassy Insider, and we look forward to more Embassy Insiders in the future. Anyone who has case-specific questions, kind of like the adoption one, that kind of gets into real specifics about a family situation, is there a way they can reach out to you, or what other than this?
Well, there's a specific website. Email address.
Okay.
So it's IV@state.gov. So that's capital IV Manila replies at state.gov, and they can ask their case-specific questions there.
Super. And everybody, we will post the USCIS site and the email address for case-specific inquiries on the comment section. So don't worry if you didn't write it down. We will post it for you. Again, I'm Molly Koshina from here at the U.S. Embassy. Thanks so much for joining us today for U.S. Embassy Insider. And Monique and Nathan, thank you for your time and all the answers. It was really interesting. I learned so much. Thank you for joining us.
You're welcome. It's a pleasure.